Right, Councillor Udy, the meeting's now live.
Thank you. Good morning, everybody. Welcome to the licensing subcommittee this morning. The first technical thing we need to do is appoint a chair for the hearing. Can I have nominations, please, members?
I nominate Councillor Udy to be chair.
Is that seconded?
Yeah, I second that.
Perfect. Then you're in the chair, Councillor Udy, and I'll hand it over to you.
Good morning, everyone. I'm Councillor Udy and welcome to the Licensing Subcommittee meeting. This meeting is being broadcast to enable the press and public to view the meeting. We are meeting virtually in response to the limitations placed on governance by the COVID-19 pandemic. Until recently, the law generally stated that all members had to be present in the room to make formal decisions at meetings, although it is arguable that this didn't apply to licensing committee hearings under the Licensing Act 2003. However, in any event, the law was amended in response to the COVID-19 emergency and councils are now able to hold all public meetings virtually. For the purposes of this meeting and having been advised by the City Solicitor, I can confirm that the hearing shall be run pursuant to Section 78 of the Coronavirus Act 2020, regulations made thereunder, and the Licensing Act 2003, regulations 2005, which enable the authority to establish its own procedure. Members are reminded to be available throughout the meeting and indicate if they need to leave the proceedings at any point. All three members must be present at all times to be quorate. If any part of the evidence is missed by any of the members due to connectivities or other issues, please raise the matter as soon as possible so it can be addressed. Members, officers and participants are requested to keep their microphones on mute and must only turn these on when they are called to speak. This will limit the amount of background noise which can be very disruptive. Members of the committee who wish to speak should use the chat facility and simply write their name. I'll also I can also take a raised hand. Please do not use the chat facility for anything else except to raise a point of order. If there are technical difficulties, we will endeavour to resolve these and where necessary have a brief adjournment, but the meeting can proceed where quorate. I will now explain the running order for this meeting. Members will first declare if they have any interests. The licensing officer will present the report. The members and the applicant will then ask questions of the licensing officer in that order. We also have the police here, which can also ask questions, missing from our report. The applicant will then present their case and questions may be asked of the applicant. The police, as responsible authority objecting to the application, will present their case and questions may be asked of the police. Finally, everyone will have the opportunity to sum up their case. The meeting will then end. Members will then privately meet for our deliberations and reach our decision, which will be circulated to all parties ASAP. To reiterate, each party will have an opportunity to ask questions at the appropriate times and to make their own representation when asked to do so. Parties are reminded that representations are strictly limited to those points already raised in your retrospective written representation. You are able to expand upon these points, but you are not allowed to add new. You can be assured that members have read the papers before, and as a result, you are asked simply not to read your written representation. Right then, I would now like members to introduce themselves. I will read your names out in alphabetical order. Please can you reply by stating your name and saying that you are present. I will pause for a few seconds between calling each member. Councillor Tom Coles.
Councillor Tom Coles, present.
Thank you very much. Councillor John Ferret.
Councillor John Ferret, present.
Thank you. Can I now ask the officers to confirm that they are present as follows? Ben Attrell, Legal Advisor.
Ben Attrell, present.
Thank you. Derek Stone, the Principal Licensing Officer.
Derek Stone, present.
I've got down as Lisa Gallagher here, but it's Anna Martin today, isn't it?
And Anna Martin, present.
Thank you. I will now ask the following if they are present. Mr. John Thurston on behalf of the applicant. I can see you. You're on mute, John.
I do apologise. It's Mr. John Henry Thurston, but present.
Thank you. Thank you. Sorry, I'm just going to switch back to my other bit of paper. Miss Jill Norman's not here, is she? But I've got them written down in my list because I've not seen her here. But PC Jason Pearce, Hampshire Police.
Yes, present.
Thank you very much. I will now move on to agenda item 2, declarations of members' interest. Do any members have any interest that they would like to raise?
No, I have no interest.
No interest from me.
Only a slight side note that a very, very long time ago, I briefly worked for Clarence Pier, but it was over 16 years ago and it was for a summer, so I have no interest. Thank you very much, members. I will now move to agenda item number 3 to consider the application for the temporary event notice, consideration of an objection notice, Clarence Pier Oktoberfest 2020, which is 3 weekend events. Mr. Stone, would you like to take it away?
Yes, good morning, members. The purpose of this hearing is for the committee to consider an objection notice given by a relevant person, namely the Chief Officer of Police, in respect of 3 temporary event notices received by the Licensing Authority under our reference of 02607, 02608 and 02610. The 10 submitted by Jill Norman, you may feel, on their first submission lacked any detail and originally stated 499 persons attending, and the risk assessment was also lacking any detailed information. Naturally, the police had concerns and objected to the applications, and you'll hear from PC Pearce shortly. The applicant was advised regarding the police objection and several days later submitted more information, actually limiting the event to 75 persons, so a reduction of 424 from the original submitted applications. Together with additional information, and further information was provided on the 8th of September, that being a social distancing and COVID prevention plan and 3 site plans. Then on the 9th of September, a revised risk assessment was submitted, which you all received copies of on Thursday before the Friday meeting, which had to be abandoned. The applications relate to 3 tens, as you said, for an Oktoberfest event over 3 weekends of the 9th of October, 16th of October and the 27th of October. This will be a German beer style event at Clarence Pier, Southsea, and Mr. Thurston will be able to give you more information shortly. Attached to Appendix A to my report are the applications, and members, in my report it sets out the process for applying for a 10, who can object, and the process for how a hearing must be held to determine the matter. As you know, the Chief Officer of Police or Officer of the Council exercising environmental health functions may intervene to prevent a proposed 10 event from taking place on any or all of the 4 licensing objectives. They have 3 working days following receipt of the 10 to give an objection notice if satisfied that allowing the premises to be used in accordance with the notice, it would undermine a licensing objective, and they must give reasons to support any concerns. However, at any time before a hearing is held, the relevant person may, with the agreement of the premises user, modify the 10 to address any concerns. If that is done, then the objection notice is treated as being withdrawn. The Chief Officer of Police has submitted an objection notice, which you have attached at Appendix B. Members, when determining the objection notice and whether to issue a counter notice, the committee must have regard to the promotion of the licensing objectives, the Licensing Act, the statutory guidance issued by the Secretary of State in accordance with Section 182 of the Act, the representations, including supporting information presented by all parties, and the human rights of all parties concerned to ensure both a fair and balanced hearing, and to consider, if necessary, any public sector equality matters. Any application will be considered on its individual merits. Equally, any person permitted by the Act to make relevant representations to the committee will have those representations considered on their individual merit. Members, Chapter 7 and paragraphs 7.1 to 7.40 of the updated statutory guidance by the Secretary of State are relevant to the consideration of 10s, and in particular 7.34, where a standard 10 was given, the licensing authority must consider the objection at a hearing before a counter notice can be issued. At the hearing, the police or environmental health and the premises user may make representations to the licensing authority. In this case, as there's no existing premises licence at the venue, you are not in a position to add conditions. Therefore, you either allow these the events to take place or issue a counter notice to prevent the event going ahead. After the hearing, the representations and having regard to the objection notice, the committee must then give the premises either grant of the TENS or issue a counter notice to prevent the event from taking place. That's all I need to say at this time, members. You'll hear from PCP, so Mr. Thurston, and it's over to you. Thank you.
Thank you very much, Derek. Members, questions? Councillor Coles, any? Sorry to leave on the spot quickly.
No questions from me at this time.
Councillor Ferret, any questions?
Yeah, just one to Derek. Derek, you mentioned, I think that last paragraph you read out about environmental health. This seems to me clearly there's public health issues here. Are those covered by the environmental health in terms of when they're given an opportunity to comment on this?
So you broke a little bit. I think your question was, are environmental health informed of these notices? And the answer to that is yes. Both the police and environmental health are notified of the TENS when they're submitted.
But do environmental health, because like I say, it's more a public health concern here. Are those covered by environmental health, or should public health be consulted separately?
It's not in the Act to notify public health.
Okay.
Any further questions, Councillor Ferret?
No.
Thank you. I have a question for you, Derek. As you mentioned about the nature of TENS, it's either you grant it or you refuse it, and there's no conditions on there. Could you just confirm that you can't limit the amount of people on a notice if we were to grant it today? Just to clarify that for.
Sorry, Councillor, you broke. Was that to me or was it to Ben?
No, it's to you because I know that you'll be able to answer it.
I didn't hear the question again. Can you repeat it?
If we were
I'm not getting you, Claire. I'm sorry.
That's sad. I can ask it to Ben instead. It's fine. Are you there, Ben? Ben?
Yes, yes, I am. Rocky will correct me, I'm sure, if I'm wrong, but if the temporary event notice is modified in terms of which has occurred so far to limit the number of people, then it would be expected that they will operate to that number.
Thank you for that, but we can't edit it. We can't edit any conditions on a TENS. It's either blanket. You can't
place conditions on the temporary event notice itself because there is no pre-existing premises license in this case. If there were, if it was on an area of land or at a premises that had a prior existing premises license, then conditions that already exist could be transposed onto the temporary event notice if you decided. But in this case, there is no premises license, and therefore you're not able to attach any conditions. All you can do is either, and it's I ought to also, and it's just a technical point. It's not actually technically a grant because it's not an application. This is a notification process. So you either allow the event to go ahead or you issue a counter notice. Those are the options.
Thank you for clarifying that on my first TENS meeting. We don't have these very often, do we? I'm muting myself for no reason. I don't have any more questions. So, Mr. Thurston, do you have any questions of the officer, please?
Sorry, just a secondary clarification, if I may, that the committee is permitted to limit the number of persons to the amended number of 75.
Ben, do you want to come back on that? Is that cool?
Well, as far as I'm concerned, the limit is set down in the statute at 499. If you make the application and modify your application, which is what you have done, then that would be the application that the authority would be considering. I keep saying application, of course, it's a notification. So if you were, I mean, the difficulty with temporary event notices is very little. I think it's sort of covered. The ground is covered in the report insofar as actual enforcement. But if you modify the temporary event notice application during its course, and let's just say that that modification led to a withdrawal of the police objection, then yes, you would be expected to abide by those amendments. So in this case, you have now clearly stated that the maximum number is 75, I believe, if my memory serves me correctly. Whilst I'm mentioning it, I might as well ask the question, does that include staff, or is that just those to be admitted onto the premises?
So as per my understanding of the application, that should have included the staff that were to be present as well.
So the total maximum people on the premises at any time will be 75.
Is now joining.
Sorry, Chair, I've had to come in via my phone because I keep losing the conversation.
That's fine. Sorry. Yeah, you can resume up there. So, are you all sorted? Sorry. Mr. Ferguson, did you have any questions for Mr. Stone at all?
No further questions. Thank you. That does answer my question.
Thank you. Do I call you PC Pearce or Mr. Pearce? Do you have any questions for Mr. Stone at all?
Well, certainly that. I appreciate we were seeking to get some clarity there, and I was sort of listening carefully to Ben's words. But the original temporary event notice was for 499. So just so we're all clear, anything informally agreed or otherwise beyond that, are we saying that that now forms the legal part of the document of the temporary event notice? It is formally required to be 75, or are we talking about a scenario where that's a gentleman's or gentleperson's agreement?
I think I'll just jump straight back in there, Chair. I will double check on the law as the meeting goes on, but my understanding is that there can be negotiation between the parties in the lead up to a hearing, and where the premises user modifies the temporary event notice, i.e. effectively alters what it's proposing to do, then that can lead to an agreement between the parties that the hearing is no longer necessary. So if that's the case, my logical sort of working through it would mean that the premises user would have to be bound by that agreement, otherwise it would be a pointless process. But I will double check the law on that now.
Chairman, can I just come back in there? As I saw it, the temporary event notices were as written, and what we have had since then is a written undertaking by the applicant to declare what they intend to do. I'm not sure how that document forms part of the original temporary event notice applications. As I see it, it's an informal undertaking.
Ben, could you just come back there, because that's more of a question for you. Sorry, did you hear me then, Ben? I'd say that was a question for you. You're on mute.
Yes, sorry, I'd just gone off of Teams to start trying to find the guidance for you, Chair. So it took me a few seconds just to come back to unmute. Yeah, as I say, my understanding is that the temporary event notice application can be modified by way of negotiation. So that would be a formal modification and amendment, if you like, that would be enforceable. Well, I say enforceable, but it would be an amendment of the temporary event notice. So, yeah, more than just a gentleman's agreement, so to speak. If that makes sense, it would be as if the temporary event notice was made in those terms in the first instance. If it's a formal modification of it, which I think Mr. Thurston seems to be indicating it is. Yeah.
Just to clarify, sorry if I may jump in, if there is any further formal process that we need to undertake to reduce the number, we're happy to do so. It was my understanding that the letter would be sufficient, and that was my intention. But if there's anything further required, very happy to complete that as well to make it formal.
Thank you. We can definitely cover this when we get to your bit, which is right now anyway, if you have any further questions, Mr. Pearce.
No further questions at this point.
Thank you very much. Mr. Thurston, now would be your time to state your case, as it were, for me. Thank you very much.
Thank you, members. So to sort of clarify on a general point to begin with, I very much understand the sentiment and the concerns of the constabulary from their objection. And in summary, it would appear, which is perfectly understandable, that the event was seen to be a sort of large-scale drinking event, as many Oktoberfests are. In fact, and hopefully through my clarification by way of letter and an event plan and 3 site plans, that I may have now given a revised indication that this is in fact a fairly small-scale, well-controlled family event to supplement the largely family attractions that we have here at the pier. Further than that, there's sort of nothing general that I have to say, you know, without repeating anything that's been made in a written statement. Happy to answer any questions.
Thank you. Councillor Coles, do you have any questions?
No, nothing for me.
Councillor Ferret, any questions?
No, not for me.
Okay, thank you. I have read your Appendix D, which is your letter in response, but I'm reading over it again because I'm just going over. Oh, you've got challenge 25 stuff in there. That's normally what I ask. My concern is about protection of children from harm, obviously, because you're a family site and you've explained that in your letter. So I don't have any questions. Mr. Stone, do you have any questions at all?
No, I have no questions.
Same again, Mr. Pearce.
No questions.
Thank you. We then move on to representations, and now I'll move over to PC Pearce, who is it PC Pearce? It is Police Constable Pearce. Sorry if it's not. If you'd like to state the representation, please. Thank you.
Yeah. Yes. Okay. So as I say, I'm submitting this application on behalf, the representation on behalf of the police. As we all know, the backdrop of these beer festivals is, of course, coronavirus, which presents a changing and dynamic risk. We were seeing signs of improvement during the summer. However, you will all know that the current picture is of significantly increased infection rates and what looks like another surge of a pandemic starting up. We all know the outcome of the previous surge, and I'm sure it's your #1 priority to keep the infection rates low and ensure that we don't have a citywide lockdown and all of the associated implications to both individuals and businesses. So that's just a kind of that's the setting that we're in. As you all know, PC Rackham submitted his written representation to these beer festivals, these temporary event notices, based on factors of the likelihood of increased risk of drunkenness and violence, the likelihood of increased risk of vulnerability for those who drink, and the likelihood of people singing loudly and dancing. And all of those factors would potentially increase the risk of coronavirus transmission. That was on the original application submitted. There was a lack of detail within the temporary event notices and risk assessment upon submission. There was no real clarity on how the specific aspects of the event would be managed. And as a result, the representation was submitted. Sure, you've all read through the response by the applicant, which, as we've discussed, pretty much as I saw it, was a written response that's not legally binding. It was an informal undertaking, so it will need to be clarified that if any permission is granted today for the original 10s, will it be technically for up to 499 people, or potentially 75? And I'll get to that 75 point in a moment. And you also know that you can't add conditions to the Thames. So if you are of a mind to accept the written response by the applicant, I would point out, looking at the document, it's not actually clear regarding the numbers attending. I appreciate the words said today, but we have a temporary event notices submitted, which are the first documents. Then we have this written undertaking, and now third hand, we have a verbal. Now, the actual document submitted by the applicant says, it actually says, it quotes in it, the reduction of the capacity of the seating areas from 499 to 75. Now, I'm not sure if the seating area capacity means the total permitted numbers of people attending will be 75 for the whole event, or if there will be 75 people seated with other people permitted to stand. That detail isn't in the document. It's not overly clear and is open to interpretation. Adding to that, if you look at the latest risk assessment on page 11, that kind of adds to the confusion to some extent, where it says the number of customers that can reasonably, it says following, but I'm sure it means follow, the number of customers that can reasonably follow social distancing at the venue shall be calculated and not exceeded. So again, that just adds to that sort of slight greyness there. And it does seem like there's a dilution from the original document down to the secondary document to the verbal. Where are we? So moving on, yeah, the follow-up response by the applicant doesn't give clarity on the type of music to be played, so leaves the presumption of a traditional Oktoberfest music, which would encourage dancing and chanting. That's very normal. We can't see how the event organiser will seek to take away the elements that effectively make up what is an Oktoberfest German beer festival, and we presume that they will not take away those elements. In the report, the event organiser does state that they have vast experience of events, but this will not be in the context of a pandemic, so any impression that they've done all of this before will not actually be accurate, as said in the written report. Now, the follow-up response, the written response by the applicant, states at the bottom of page 1 that the police representation has given the appearance of a large-scale drinking event, which I think Mr. Thurston mentioned earlier. It goes on to say, in fact, we only seek to add a small family-based offering of alcohol, authentic German food, a friendly and safe atmosphere to largely family visitors. The most up-to-date risk assessment states on page 7 under children that no children are permitted to the evening openings. So I'm assuming that the evenings are not in fact family events as described in the follow-up email by the applicant. We can only assess an Oktoberfest German Beer Festival event on what is applied for and what it's always been, which is an adults drinking, singing, dancing to music event. So we will assume it is that. So it needs to be clear there that it's okay calling it a family event, but it's not in the evening. I say events, I mean. I'll just make mention of the fact of the risk assessment. On page 10, it mentions 2 family groups, which may be aligning to past requirements. However, I'm sure we'll all know that changes come into play today. Would like to know a little bit more about the egress plans. A bit concerned about that. Not quite sure how the premises will manage this. This will be a significant point of the evening because a lot of intoxicated people will be leaving together. I think most importantly, such events with the best intentions, they do have the ability to start well, then descend into groups getting up and dancing and gathering as the alcohol affects people's inhibitions. It was only the weekend before last that I went to a very nice event, on duty to check it, I mean. Very civilised to start with, but ended up in lots of people dancing together, close together, in front of the music. And it's for this reason that we have to treat these events with caution because of the current climate. Where there's a potential risk of people gathering at alcohol-related events, the authorities, police and environmental health, we are encouraged to assess the events with caution and refuse or object to them if there is a potential risk of the virus transmitting. So it's right to err on the side of caution, especially at a time when infection rates are increasing. So in this scenario, we feel that there's a clear associated risk, and it's only right to refer the matter to yourselves to decide if this is the type of event you wish to have in Portsmouth. Certainly seems to be a few areas that need clarity, but overall the police still feel that an Oktoberfest German beer festival shouldn't be approved at this point in time, and that ends the initial police input.
Thank you very much. I just want to say that Mr. Pearce did raise some concerns of the applicant, which you are able to address in your summing up. So when I ask you if you've got questions, please ask a question instead of saying other stuff, because we can definitely assess it when you're summing up. And Ben has his hand raised. Hello, Ben.
Hello, Chair. Thank you. I just thought it might be worthwhile before you move to members to ask questions, just to address the legal question that's been raised a couple of times.
Cool. Thank you. Yeah, you can address that. Thank you.
Thank you. So I did manage to find the guidance, and the relevant paragraphs are 7.36 and 7.37, and in particular 7.37. Which, and I'll just read it to you. As noted above, the police or environmental health as relevant persons may contact the premises user to discuss their objections and to try to come to an agreement which will allow the proposed licensable activities to proceed. The 10 can be modified, for example, by changing the details of the parts of the premises that are to be used for the event, the description of the nature of the intended activities or their duration. The other relevant person has to agree for the modification to be made. There is no scope under the 2003 Act for the modification of a late 10. So this is not a late 10, this is a standard 10, so it can be modified by agreement between the parties. And I think that goes to the nub of the question that PC Pearce was putting, was would any agreement actually be a valid and proper actual agreement of the original application or amendment of the actual application, or would it be just some kind of gentleman's agreement? No, it is a formal amendment. It's a proper modification if it's agreed between the parties. So I think what we have here is something that was offered up by the applicant, and as far as he has indicated on behalf of the limited company today, it's to be considered in that way as a modification of the application. So I think you can consider it that way, Chair.
Thank you very much.
I hope that helps.
Mr. Thurston might want to come back on that.
Yes, thank you very much. That is the case, and I do have a few very brief responses to those further concerns that were just raised by the constable there, if I'm permitted.
Yeah, I'm saying that it would be on during summing up at that point, so you can ask questions of the constable, but at the end we can sum up and you can address those points perfectly, because we've got to move on to questions first.
No.
Ben, you were trying.
Yeah, I was just going to say you might want to ask the members if they've got questions first, but if there's anything in response to the legal point that I've raised, Mr. Thurston, at this stage.
No, thank you.
No, perfect.
Could I ask a question? Sorry for jumping in, but I haven't got hand up facility of you, Ben.
Yes, absolutely.
Yeah, looking at your words, I'm sort of a bit of a devil's in the detail. You say the police or environmental the guidance says the police or environmental health may contact the applicant. Yeah. So it assumes that we may go to the applicant in the first instance to discuss potential modifications that suit our needs. This isn't what has happened in this scenario. It isn't that way around at all. We have been presented with another set of options by the applicant, or another set of measures by the applicant. We haven't presented that to the applicant for the applicant to agree or disagree. I think that's quite important. I just make mention of that on a legal.
No, I think that the subcommittee can take note of that fact and attach weight accordingly. And I think probably what the members will want to know is what issue, if the subcommittee were to accept the changes that the applicant is saying they will implement as a modification as such, what issue the police would have with the event if it were to run entirely in accordance with that modification.
That answered that. Mr. Thurston, you have your hand raised again. You're on mute. You're on mute there, Mr. Thurston.
Thank you. On the 3rd of September, when I received the objections from the constable via Derek Stone, I was offered with only 2 alternatives. And I'm just going to read from my email here an excerpt from past experience, and this was sent to Derek Stone. From past experiences with TENS, I believe a further option you have not listed on your email is possible, that we may be able to satisfy the objections by way of explanation, and I attached a PDF containing my letter, to negate the need for a hearing. If Hampshire Constabulary find the response satisfactory, then they may consider withdrawing their objections. So I effectively am saying that I did offer an alternative for dialogue, which was not responded to by the constabulary.
Yeah, I'd assume that's the evidence that we in front of us right now. Ben, did you want to just come back on that? I'm quite clear of what's happened here, and maybe TENS might be dealt a little bit differently in future, but we don't get many TENS refusals. They're about 99% accepted, aren't they? Under
yes, generally as a matter of course, unless there's some specific objection, they will go through without the subcommittee being involved. There's not really anything else that I can add, I don't think, at this stage, unless you have specific questions.
Thank you. I'm going to move to members' questions now. Members, do you have any questions for Mr. Pearce?
Nothing from me.
Anything for you, Mr. Ferret? Councillor Ferret?
Yes, PC Pearce, you clearly have mentioned the context in which this application is being made in respect to COVID-19. Now, there are new laws coming in today. I'm not sure if the government have actually published them yet, but clearly they've been announced in terms of the rule of 6. I defy anyone really to understand what the rules were and what the rules are surrounding this, but hopefully the police are aware of what they are if they're being called upon to enforce them from today. So how does the rule of 6 and the regulations that are being announced today, how does that change this application? How does it change what's being proposed, if indeed it changes it at all?
Yeah, in your own words, this is difficult to fully understand. We haven't been given detailed information of interpretation at the moment, but the reason for myself mentioning it was that in the report by the applicant, it clearly makes reference to the previous legislation where it talks about 2 family bubbles being there, where now that legislation's going, or that guidance is going to change to legislation where this rule of 6 is going to come in for indoor events. I mean, I can give you my interpretation of the legislation, but the point I was making was on the point of it's not now 2 family groups, it's different now. Certainly from my understanding, it's only my interpretation that if groups of 6 people, if 10 groups of 6 people went into a premises, all separate, and they were unconnected to each other, they could all go and sit at their table of 6. If a group of 60 went in together as a party, they couldn't do it, and they all, even if they all sat at separate tables of 6. That's my simple understanding of the basics of the legislation. So in some ways, oddly, on that point, the government have actually made it easier for people to gather in groups of 6 from different households than they had before. So it's possibly a relaxation rather than a tightening of the legislation on that point.
Okay, just to follow up, in terms of the events, because as I understand it, you couldn't have a wedding where you had 75 people present, but you could have an event such as this where you've got 75 people present. Is that correct?
Yeah, it's a bit like a pub that may have a coronavirus capacity of 100 is allowed to have 100 people in that building, as long as they are, we're talking about what's current now, as long as they are coming in groups of 6 but not connected to each other. So it's an oddity really, because it still puts that many people within a room, and if you're focusing on the air, the distribution of breath into the air, that kind of thing, it probably makes not a lot of difference, but those are the rules.
Yeah, oddity is one word for it.
Thank you, Councillor Berwick. I have a question, please. If we didn't have coronavirus, would the police allow this event to go ahead with the amendments that were sent in from
Yeah, I think. I mean, I didn't submit the original application. I'm picking up the report afterwards, but in simple answer, I think not. I think this is all about accepting that even though there's a tendency for everyone to get a bit weary of this and a little bit complacent maybe, I think this is all about there's a real and present risk out there, and as authorities we need to be doing the right thing, however difficult that is. But in answer to your question, I think no. Personally, it would be a no from me. Wouldn't have objected if coronavirus wasn't part of the factor.
Thank you. Mr. Stone, do you have any questions?
No, thank you.
Okay. Right, then we move to summing up as far as I'm aware. What way are we going first? Miss PC Pearce, would you like to just sum up, please, for us? Thank you.
Yes, of course. I'll keep it short. Police would say that the event's not suitable at the current time. It has too many associated risks related to coronavirus. It's not just a family event as purported to be in the document. It is an adult event in the evening, and however you look at that, we all know what an Oktoberfest event is. It can't be something different to what it is, which is German music, German beer festival, singing, dancing, drinking. Doesn't fit with coronavirus, unfortunately. But ultimately, we would simply say that we're just raising those points to you for you to make a decision on what image you wish to portray for the city of Portsmouth at this difficult time. I'm afraid that's all I've got to say in summing up. Thank you.
Thank you very much there. Mr. Stone, would you like to sum up, please? Thank you.
No, I have nothing further to add. Thank you, Chair.
Thank you very much. Mr. Thurston, if you'd like to sum up and maybe address those points that Mr. Pearce had brought up in his representation. Thank you.
Thank you very much. I won't take long. In relation to the contradictory information regarding capacity, I do believe that the information actually all supports each other, in as much as 75 would be the de facto limit capacity by licence for the entire area, and the entire area encompasses the 2 seating areas. So I hope that answers that question. In relation to pandemic experience, yes, my company does have experience. We are operating in other areas of the country, drive-in events, outdoor events, large-scale circus events that all come under the outdoor event term by law, which just to clarify from our perspective, this event, the constable mentions air quality, this event is considered an outdoor event due to the nature of the temporary structure that it is encompassed within. And just to address the referencing 2 family groups or the rule of 6, yes, I do believe that the rule of 6 has come out since the initial risk assessment was submitted. And from our perspective, it goes without saying that we would obviously comply with any more up-to-date legislation as may develop, past this point. With relation to the evening and the family comment, it's also possible that we are happy to discuss this as a way of a further amendment with the constabulary to effectively remove evening events so that the event is purely a family and a daytime event, which would also address his concerns with regards to egress, and that would permit a more gentle reduction in numbers as the event draws to a close rather than a tipping out of a large number of people.
I'm sorry to interject. Ben's waving at me.
Yes. Thank you, Chair. I know what you're saying about further. You'll be willing to accept further amendment. If you're going to modify your application, you really need to do that now, because this is not something that the subcommittee could sort of consider and then impose. It will have to either allow the event or disallow it. It can't actually amend it of its own volition. So if you're saying that you're going to change the hours to try to appease the police objection in any way, shape or form, you need to say that now. And I think the police then ought to be able to be given an opportunity as well, Chair, to just comment on that also, as to whether or not they feel that affects their viewpoint on it.
Thank you very much. Thanks. Mr. Thurston?
Yes, so thank you very much for that clarification. If that is the case, then I would be happy to do so now, and I would be happy to reduce the opening hours to finish at 6 p.m, no later on any evening.
Thank you very much. Just back to you, Mr. Pearce. Do you have anything to say on that matter?
Not really, Chairman. I don't think a knee-jerk response would be appropriate. I think it's this changing with a give me a quick answer kind of thing. I don't see this is all in keeping with the process. We should be assessing on the initial document. Beyond that document, as I see it, there's an informal undertaking, which was the letter, and then any adaptions today are further to that. I just think that it could get if this was the scenario for all temporary event notices, it would get really messy, and we really need to default to what was submitted on the application, or if the guidance permits that the police seek to contact the applicant to make changes, if that's acceptable, that's all before this hearing. I think it's inappropriate for us to be making a knee-jerk response on that today. Sorry to be non-committal.
No, that's absolutely fine. You're within your rights to do that. Ben, just a legal question. Obviously, the relevant authorities have 3 working days to object to attends at the moment. Is that because of the Coronavirus Act, or is that because that's the in general?
No, that's the standard legislation. There's a very limited period within which to lodge an objection.
Thank you. And because it was so, I guess, because this application came in so far and so late to when the actual events are happening, we need to get this through. So if there is an appeals procedure, it needs to be allowed to be heard. Is that correct?
Well, there's an element of that, yes, absolutely. But it's the standard process, and this actually isn't a late application. This is a standard, a general 10 notification.
Thank you very much. Mr. Thurston, would you just like to finish summing up and then we can move to exempt session?
Yes, on this point, it may be a sticky point, but I think it is one worth sticking at. Again, I would repeat, we offered via Derek Stone to enter into a discussion with the constabulary, and I have here an email that I sent on the 1st of September offering to open this discussion. It was not responded to by the constabulary. So for them to now say that they are not willing to discuss my knee-jerk reactions, I am merely exercising my right to this discussion, which they were offered prior to this hearing.
Would you like to end it there? I guess there's many factors to this, and I guess one is that when I was made aware of the application, there wasn't a lot of information submitted with the application, which kind of makes the process a little bit more difficult going back and forth. Would you agree with that, Ben? And Mr. Stone in general as well, that when everything's not submitted and everything has to be heard back within 3 working days, then I would assume naturally there would be an objection to an event during coronavirus that was offering no information about what was happening. And obviously you submitted that evidence after the objection. Is that right?
That's what's happened, Chair. There seems to have been a lack of negotiation that's followed, and it is the way it is. So there's nothing that can be done to change that now.
I would like
Sorry, Chair, may I, just as we're being sort of maybe accused of a lack of negotiation,
yes.
I think it's only fair that I can just say the point that, as we saw it, it's based on the original temporary event notice. Anything after then, without us going to the applicant, is informal agreements, and we based our lack of mediation engagement on the fact that this was all going to be informal, and we didn't think that was appropriate in the current circumstances.
Thank you very much. I think we can all agree that we've kind of reached some kind of agreement over what happened during the process of this meeting, but I can assure you, Mr. Thurston, that during our deliberations that we will look at all the evidence that is before us and make a reasoned decision today. Thank you very much for all your time, and thank you, PC Pearce, for coming in today. Members, we're going to end the live stream now, and we'll meet in exempt session. We should get the decision over to you by the end of the day by email. By Mr. Stone will email you promptly. Hopefully it shouldn't take too long. Members, I'll see you in about 5 minutes. I'm going to make a coffee.
Okay, so we'll formally end the meeting now and stop the live stream.
Yeah, that's it. Thank you,
Right,
everyone.
okay. Thank you.
Have a nice day, because it's going to be hot. See you. Bye.